Well, hello everyone. We are live with Level Up Law, back with part 2 of nursing homes transitioning in and transferring out. So welcome and thank you for joining us today. Just as a reminder, every Tuesday at noon, South Carolina Legal Services is leveling up your legal knowledge on the different areas of law that we practice in, and we really appreciate you tuning in. I'm Susan Ingles, Senior Staff Attorney with South Carolina Legal Services. As always, joined by our producer, Kenneth Elliott from our IT department. And once again today, I'm delighted to welcome Kirby Mitchell, the managing attorney for our medical legal partnership, and Mike Large, excellent elder law attorney in private practice down in Surfside Beach. And appreciate you guys joining us again to talk about the subject of getting into the nursing home, but then really transitioning back out. There's a lot to talk about there. So let's get started. So we'll be talking about both of these things, transferring into and out of a long-term care facility. So first, let's talk about transferring into. We talked last time about all of the considerations that come up when suddenly this is what you need, even if you've planned for it. So let's look first at a little bit of statistics about how nursing home care and residents is getting paid for. And these are just some figures from the last quarter of, I think, 2019. So you can see that the two biggest payors are going to be Medicaid and also Medicare Part A. So that's something to think about because that is an influence on what's going to be happening as you make that choice and transfer. Okay. Wanted to also, just from the financial standpoint, mention the effect of private equity on nursing home administration. We don't always think about the fact that who's really handling the operations of a nursing home. It's not really always just the people who are there on site that you might meet and have contact with, but there are very large corporations that are kind of running that show. And so it's important to know some of these things that we mentioned here in this slide, and that is, of course, they are profit oriented. Sometimes the staff, especially I think right now, staff levels are low. Usually that's because of cost cutting reasons, but I think right now it's also because of some impact of the pandemic. Also, nursing homes are going to have service contracts where they're really contracting out a lot of what they do to third-party vendors. So it's not necessarily the staff there that are handling things. Other things like preferential admissions, wrongful eviction of Medicaid patients, which we'll be talking about today. And then also the idea of sending Medicaid patients back to the hospital to restart a Medicare benefit period. So that does happen. Medicare has certain benefit periods, and those can really come into play when paying for nursing home care. All right. So I'm going to bring in Mike Large here, and Mike is one of the co-authors and contributors to the book that we mentioned last time. If you have it, hold it up again. I know you and Kirby both contributed. But it's a complex process transitioning into a nursing home. So can you talk a little bit about what you usually tell clients in that regard?
Sure. It's a medically based decision, and it's got to be supported by a doctor, an assessment, and a doctor's recommendation. And it can come from home or the hospital. And at home, there's typically is going to be an event that has occurred where you can no longer live safely there, say a fall, or maybe you know, a traumatic brain injury, or even possibly you've been at home for a while and now dementia or Alzheimer's has reached a point where even a loved one can't care for you there. Now, with an event that takes you to the hospital, like say a fall in a bathtub, and now you've broken your hip, and you're in, you know, they're going to do hip, you know, surgery on you in the hospital, but there comes a point in time where they want to discharge you, right? You're done medically speaking with the operation, and you're not going to rehab there. So you're either going to be discharged to go home or to a rehab facility. And so this is typically where the transfer planning comes into play, because you have a social worker that's assigned from the point of admission to the point of now having to discharge you to a safe place. It's going to be either rehab or, you know, put in the protective measures necessary at home so that you can recover there. And so there's a lot here that has to do with the hospital's needs driving, right, getting that bed availability, and influencing the social worker who should be putting the patient in the best possible position, right? What's the care plan that's going to help that person the most should be the driving factor. And certainly, you know, nursing home facility that can provide those services, that is local to the family. All of those are important to the family, but there's sort of this tug of war. And so this is where patient and family input are critical throughout that process. I'm sure that Kirby, doing the nature of his work and what goes on there, has run into these kinds of issues. Is that fair to say, Kirby?
It is, Mike. Yeah, thank you, Susie. Mike, good to be back with y'all. I'm talking to you from our medical legal partnership office here at Prisma Health in Greenville. Certainly their goal, I think, is to get the right care to the right patient at the right time. You don't want everybody to go to the emergency room or end up in the emergency room, or as Susie alluded to, a bureaucratic non-medical reason to send people back through the hospital from what could be good, stable care just due to a billing need. So yeah, this is what we want to talk about today, is building on what we talked about last week, you know, getting into a nursing home. Today's focus is how to stay in one, how to avoid discharges that you don't want or at the time you don't want. So yeah, that's the key transition period, and something the hospital struggles with on a daily basis.
You know something, and we were at South Carolina Legal Services, we were asked to participate while I was there on a task force to deal. This was part of the vulnerable adult task force issue at hand, was how do you help these folks? There's no one particular way. There's no transparent, you know, seamless way of dealing with this issue. The hospitals are at wit's end, right? To what to do and where to send them. And, you know, unfortunately, there's sometimes not a very good answer.
Right, and we have a little bit of a laundry list here of some of the problems that might arise that you really don't even think about, because you would hope that it would be a seamless transition from the hospital. You know, arrangements are made and all that, but there are issues like transportation, your medications kind of lining up for you as you leave the hospital and go to the long-term care facility, and you know how all of that's going to be set up once you get there. And so it is important to kind of look at all of these things and realize that there's a lot of questions to be answered. And, you know, lots of times, as Mike alluded to, you do have a social worker at the hospital that's really helpful with all of that. But it's important to, I think, be you know, self-aware as a patient or a caregiver to make sure that you're not just turning it over to that other person, and that you're, you know, as you said, actively engaged. So Now, there is, just real quickly, we can touch on a transfer to a nursing facility from another nursing facility. Mike, can you elaborate on that a little bit?
Sure. It really is a risk-benefit analysis that you have to deal with before even attempting it. You know, nursing home care is not always going to be better in another facility, like the slide says. And I think it is important to consider advocating for improvements and accommodations to meet that loved one's need that's a resident in the facility first. You worked hard if you've done your due diligence and you found a facility that met all those needs initially, and you're finding that they're not being met now, you really have to be actively involved. And as Susie said earlier, the family is the biggest advocate, right? You can't rely on the social worker. You can't just rely on the staff that's there. You do need, and if it's possible, have a family member get involved to, you know, advocate for those improvements. You certainly don't want to make the transfer as a knee-jerk reaction to the current situation that's leading you to even consider it, right? Because this requires planning and certainly a whole bunch of due diligence. So.
Okay, so we want to touch on today some of the common problems with the paperwork that is involved when a patient is transferring into a nursing home. And I think, as we did discuss a little bit in part one, how you as a caregiver, or even sometimes as a patient, have so many things coming at you and so many decisions to be made, in addition to just the emotion and stress of your loved one transferring into the nursing home situation. And sometimes we overlook or don't really focus enough on the all-important paperwork, because it, you know, it often seems like, okay, here, just sign right here, and we'll get your person, you know, in right away. He can come in tonight, or she can get here in the morning. Just sign here. And as I think we mentioned in part one, and as I always say, it's so important to read the terms and conditions of what you're signing. Especially, I think, with this kind of paperwork, there's a lot of blanks to be filled in. Things like, who's the person signing the paperwork and what's their connection with the patient? Who is going to be, you know, making healthcare decisions? Is it the person signing the paperwork right now? Who's paying for this? How's it being paid for? Is it all by Medicare? Is it all by Medicaid? Does it include any long-term care insurance or any, you know, private funds that you're, you know, having to write a check out of your own bank account? So you're thinking about all that, and there's all those blanks to be filled in. So you need to participate, am I right, in filling in those blanks? Don't just let them be filled in for you.
Yeah, there's a level of planning that has to go into this. For instance, it's Medicaid that pays for the long-term skilled nursing home care after 100 days of Medicare. Medicare is only the first 100, then it's Medicaid. And so there's, you know, there's some planning, because you certainly don't want to go into a nursing home needing a Medicaid bed immediately. It limits your options, right? Because there's a lot that the nursing home can do to pre-screen who is admitted to the nursing home. It's once you're admitted that you have a number of rights. And the other thing too is long-term care insurance. Not many people have that, but if you do, there's a program through South Carolina where it's a partnership program where you can protect dollar for dollar for Medicaid the amount that you've paid into that long-term care. So there's a bunch of considerations that are financial as well as you know, health related and care plan related.
So next we can just touch on a little bit how these contracts work. You know, you're a signer on the, you know, admissions agreement. And we'll talk a little bit in a minute about arbitration clauses, because those are most often being are part of the required documents to be signed as well, which is also one that you really need to read the terms and conditions of and understand. But you know, typically you're signing as what's referred to as the responsible party. Is that right?
Yeah, Susie, that's right. Identifying the person who has capacity to sign is often an immediate issue. If you've got a senior who's starting to have a decline in their cognitive abilities, sometimes you have a family dispute right at that moment of, am I the daughter going to make decisions, or am I the son going to make decisions? You know, and it really speaks to what we discussed in some detail last week, trying to have all of that addressed, sorted out, and discussed, even if it's a confrontation, kind of having that family resolution prior to the moment you just referred to, where you are signing and filling out the documents regarding nursing homes. This is a formal process. The actual discharge, unlike, you know, back in the day when you could walk in and out of a hospital, you really can't do that today without a fair chunk of paperwork. I had a friend that I took to the emergency room here in the middle of the pandemic. He thought maybe he had COVID, so we went to the ER, and he decided to leave at some point when realizing that wasn't the issue. And good Lord, y'all, the staff kind of chased him out the door as he was coming to my car. You know, he was leaving what they call AMA, against medical advice, but just needed forms signed, and you know, he just didn't want to wait, which was against my advice. But this goes to the point that discharge is a formal process. So think of it that way. Certainly the hospital staff faces a pretty regular and enormous amount of training and threatened audits and threatened fines. And you know, this is a formalized process when there is what we are calling a discharge, the formal moment that you are leaving a facility. So that's become an extremely regulated process, and that's what we want to help folks kind of think through today.
Yeah, I think that's important. I mean, that's for the patient's own protection as well, not just, you know, paperwork on behalf of the hospital, which obviously is important for them to have, but they want to make sure that as you're leaving that that hospital, that, you know, you're going to be safe and not at risk for the reason that you came into the hospital or otherwise. So some of the other items here on our list about residents' rights as you're making that transition and signing paperwork. I know that you can't require a third-party guarantee of payment to the facility, and I think we'll talk about that maybe more in a little bit of a little more detail in just a moment. But I think it's important to realize that if you're signing an admission agreement on behalf of the patient in whatever capacity, which you should note on the agreement what that capacity is, that doesn't mean that you're guaranteeing payment in any way, certainly. But I do think there are times when caregivers or those who sign the paperwork are led to believe that they are required to pay those bills for the patient. And as I understand it, as a responsible party, you just have to do whatever is necessary to assist the new facility, the nursing home, in getting payment from whatever sources are identified on behalf of that patient. How does that work?
Yeah, well, they're always trying to get paid no matter from whatever source. And so while you shouldn't have to be a lawyer to review these contracts, it's a lot like buying a car or renting a commercial piece of property. I mean, how much can you really know what's in those documents, right? We call A lot of times we call those adhesion contracts because there really is no negotiating room on that type of contract. There's a school of thought by some lawyers that you shouldn't even try to negotiate those terms because you want to get that person into the nursing home, and then if there's an issue after the fact, you would be arguing that you really had no negotiating room. You had to either sign these documents, take it or leave it, to get the loved one into the hospital. But with that said, there are a number of ways that you can see on the slide that the nursing home tries to shift the burden in ways they shouldn't be doing, right? And so, you know, a co-signer requirement to have you guarantee payment, whether you're a family member or an agent under a durable power of attorney. You know, there's many ways to attack that. And I think that, you know, you should have a conversation about that. You should ask questions about that and make sure that's not what you're signing, but you shouldn't have to negotiate any of that while you're checking somebody into the facility. I mean, that's the practical side of it. There'll also probably be some kind of waiver of liability, right? They don't want to be responsible for if somebody falls out of bed to have some tort liability, right? Some sort of personal injury lawsuit. They're going to try to have information, you know, a clause in there waiving that from. And by the way, each nursing facility is usually privately owned by different types of equity groups and corporations throughout the United States. I just visited two where they do primarily business out of state, and they've recently come into South Carolina. So they're going to bring that type of approach to contracts into South Carolina and maybe test the waters, right? But you shouldn't have to, you should be aware of these things, but you shouldn't be thinking that you're going to have to negotiate something there at the table that day.
Right, and I think it's also important to keep in mind that the person on the other side of the desk or table from you who's working for the nursing home, you know, is a human being, and they can make mistakes, or they can, you know, gloss over something that's really an important point. You know, maybe they're thinking about something else, or they're having a bad day. So think about that as well, that they may not be at their best at that moment, and really thinking about making sure that you know what you're doing and that, you know, they're explaining what it is that's being signed.
They're not the corporate legal department that's checking you in either.
That's right. That's right. And that's who ultimately is going to be making decisions about issues. Well, Mike, can you tell us a little bit about the Nursing Home Bill of Rights? I know that's an actual statute here in South Carolina.
It is, and it's lengthy. And I certainly invite the viewers to take a look at that online. Just type in South Carolina's, you know, Bill of Rights for residents of long-term care. All right, you're going to find it on Google, but it's just, you have all of these rights to be informed in writing of changes, or, you know, the right to choose your personal physician. I'm just picking a few. Right to participate in planning and care and treatment, to be informed of changes in care and treatment, and so on. It's very lengthy. And then on top of that, there are federal rights that provide addition. Not only are they similar to this South Carolina Nursing Home Bill of Rights, but they provide additional rights. And so some of those are the right to be free of corporal punishment and involuntary seclusion, right to reside and receive services with reasonable accommodation of individual needs and preferences, the right of families to organize a council, the right to return to the next available bed after hospitalization. These are kind of where the rubber meets the road type of rights. These are like basic rights that any resident of a nursing facility should have, and they're extremely important.
Yeah, and we'll definitely link to those provisions down below when this video is posted on YouTube. So we'll be sure to have easy access to that information for everybody. One more item on the the actual documents themselves, and that is the arbitration. Here we call it the arbitration clause, but it's really a separate agreement. It's an arbitration agreement, and that's how the law of arbitration works. Is it is a separate agreement. It can't really be embedded into a contract in the typical way that you see. And what for those in our audience who don't know what an arbitration clause is, maybe I'll go to Kirby and let you just kind of explain what does an arbitration agreement actually do?
Yeah, briefly, we could talk for quite a bit about this topic, but yeah, just in summary, arbitration is an alternative form of dispute resolution. So instead of going to the courthouse and being in front of a South Carolina or federal judge, you go to a private location usually and have a arbitrator. Usually that's someone who maybe is a attorney or a retired judge or just someone that the parties have selected usually. And so it's often thought to be not favorable to the plaintiff or the patient or the complainant, because this is another way, as Mike referred to, private corporations are trying to predict and control their costs and unpredictable things like litigation and complaints. So they often tend to favor arbitration. So basically telling you that if you have a dispute, you sign these forms and you agree that that dispute will be handled in arbitration. You're giving up your right to a jury trial, which is generally the starting point in American jurisprudence. So we could talk for quite a bit about it. There's been a lot of active appellate litigation in this area. Generally speaking, the federal courts and federal statute tend to favor arbitration if there's a dispute or interpretation. But I'm pleased to see that in South Carolina, our appellate courts have tried to carefully limit that where appropriate, particularly in these nursing home cases. If you're someone's power of attorney, that doesn't usually or often mean that you have the authority to waive someone's right to a jury trial, either knowingly or unknowingly. So that's kind of the gist of the tug of war, that arbitration is usually not what you as a patient or a family member of a loved one, you probably would prefer not to have an arbitration be mandatory and would still want to have your right to go in front of a court or a judge if you do have a dispute.
The unfortunate part is the United States Supreme Court, though, issued an opinion in 2017, Kindred Nursing Centers versus Clark. And what they did, they said that the Kentucky Supreme Court's decision that an arbitration agreement executed by a principal, that's the person who signs the durable power of attorney, their agent, it was invalid because the document didn't specifically state with a clear statement the agent had the authority to enter into an arbitration agreement. And they said, no, that clear statement rule violates the Federal Arbitration Act by singling out arbitration agreements with disfavored treatment. And so this is a trend now that's been going on for a while, and it'll be interesting to see how our court system deals with that, because nursing home arbitration cases aren't litigated and appealed every day. It's not like a hotbed of activity, but it will be interesting to see how that plays out moving forward.
Yeah, and I think that the cases here in South Carolina do seem to be very fact specific, and that's kind of what we've been talking about today. Things like who is signing, what is the authority that they have to sign. The Adult Health Care Consent Act sometimes comes into play, and quite often in nursing home litigation, there's not a power of attorney, or the person who signed in the patient didn't have the power of attorney at all. So there can be all kinds of issues that come up. And so depending on the facts of a certain situation, you know, an arbitration agreement may or may not be valid in a particular case. But that U.S. Supreme Court case certainly does have, you know, some validity, and obviously, you know, does need to be considered when it comes to. And I would point out too that a lot of the cases on some of these type of issues, at least in our own appellate courts, seems to come by way of unpublished opinions. And what that means is typically that that case and the holding in that case cannot be relied on as some sort of precedent for another case. In other words, it's only on those, only decided on the particular facts of that situation. And so I think that's probably why I'm saying that it's very fact specific in many of the cases here in South Carolina, depending on what kind of lawsuit it is, what, you know, different rights a patient is saying have been violated, whether it's under the contract or under some sort of a other common law complaint or statutory duties and those sorts of things. So yeah, I think it's important to know about this arbitration thing so that you realize that that may come up. And arbitration quite often starts in a way other than a lawsuit. And, you know, you just may get some sort of a, you know, notice of arbitration. But if you're filing a lawsuit, then it's usually going to come by way of a motion to compel arbitration when you've actually wanted to go to, you know, the regular circuit court and, you know, have jury trial. One other issue I just want to mention is this merger idea. There are some of these cases that we've just mentioned that talk about whether or not the admissions agreement and the arbitration agreement are merged and sort of become one. And that, I think, is the issue that is also somewhat fact specific. Okay. So, Kirby, I'll let you take over on this one.
Yeah, we can move through the next few slides pretty quickly. I just want to give people an overview, and they'll have this resource. You can save these PowerPoint slides for later if this issue comes up for someone that you know and love or a client that you have. So just know that these nursing homes we're discussing are quite regulated by a mix of state and federal law. So here's the citation to the federal law that you really want to start with, 42 USC 1395. So any facility that takes Medicare, Medicaid, any payment like that, they're going to be controlled by and very versed in this law. So that's kind of the starting point. We mentioned, next slide, Susie, we mentioned a lot of the paperwork that's involved. A discharge is a very formal process. And just, this looks like an intimidating slide, but just two things to note. You're going to hear reference to the MDS, that's a minimum data set document. So that's kind of a standardized form that all the facilities are going to use as an assessment tool of the health status, kind of a starting point. So you'll hear reference to the MDS if there's going to be a discharge or change. And then the PASRR, the pre-admission screening and resident review, that's another common and very lengthy document that provides sort of a medical background and basis, kind of evaluating where the person's at with their abilities and mental health and what services they need in what setting. So just if you're having some questions about a facility or not sure if you've got a loved one in the right facility, these two documents are going to be key and something that will be something you'll want to have a copy of and be familiar with. Next slide, Susie. So that's kind of the overview and paperwork. How can someone be discharged or forced to transfer from a facility? I'd say there's 6 reasons. Here's the list. Number 1, that the move is necessary to meet the resident's welfare. That you'll hear that if the facility simply feels like the medical needs are not something they can meet at their nursing home. Number 2, the health has improved and you no longer need to be at the facility. That's not all that common, but certainly now as we see different stratification of care, this could be more common where someone goes from different levels of assistance and care. And so that can be a good thing, certainly. I think you'd like to have that reason, that the health has improved to the point where that's documentable and provable, that whatever facility you're in is all that care is no longer needed. Number 3 and 4 are really part of the same issue, where the safety and health of other residents are endangered. Unfortunately, sometimes folks with Alzheimer's or other conditions become quite combative and physically dangerous to others. So we see that from time to time. A facility feels like they simply can't protect the other residents because of one resident, or perhaps a communicable disease or some other condition that affects the other residents. Number 5 on this list is the one we see the most, non-payment, where someone has run out of money and there is a period of reasonable notice, but no payment for whatever reason. And then number 6, unfortunately, sometimes, private businesses go out of business or go bankrupt or have a need to stop, and that can be the cause of kind of unfortunately, a group transfer or discharge. So those are the reasons you'll see. Next slide, Susie.
Okay. So we're going to really get into the issues here on discharge.
So if I may, to Kirby's point on numbers, I forget if it's 3 and 4 or 4 and 5, where it's the health and safety of others is endangered. That oftentimes comes up, as Kirby stated, Lewy body dementia has a physical component to it where, they lash out. And so the nursing home doesn't want to deal with that type of patient. And so 2 defenses that I've had some experience with are, first off, is there a safe alternative to transfer them somewhere? What makes this other facility a better facility to care for that person? They certainly can't come home, right? Dementia is progressive. There's no cure. They're at the nursing home facility for all the medical reasons necessary, right? So where are they going? And then let's not forget, will this transfer harm that person, right? So you've got those 2 right off the bat when we're dealing with that type of situation. And I've found, and I've spoken with other colleagues, you really got to look at what has the nursing home done in terms of documenting the daily care logs and other medical information. What have they been doing to address that issue? And oftentimes, if you really look hard, you're going to find some things to defend against and possibly reach a resolution without even needing a fair hearing. But I'm sure it's different for different situations, different circumstances.
So you have a lot of due process rights when you're facing a discharge situation. So there has to be a written notice, and there has to be pretty clear reasons stated, like the ones we outlined. There can't be a vague reason that's kind of new. It has to be something that would be well documented in the medical record and paperwork that the facility has. Next slide. You're given 30 days notice usually, and unless there's some extreme emergency situation, but lots of requirements about what the notice must contain. So we've listed that here. if that becomes an issue for you. Next slide. The ombudsperson is someone I want to discuss. You know, you have a right to appeal, and you certainly have a right to an attorney in these cases. A lot of folks, though, could probably get good resolution, or at least the start of a good resolution, by our state's ombudsman program. Next slide. I had a case a few years ago where I was frustrated with the responses I was getting from a nursing home's office, and even though I certainly had the ability to file a complaint and send subpoenas and engage in formal litigation, I contacted the local ombudsperson, and I was impressed. You know, the facilities have a healthy respect / fear of the state's ombudsman program. Next slide, Susie. It's something I think that is supported through federal law, but here in South Carolina, we have a pretty good, I think, from my experience, pretty good group of ombudsmans. They've broken up the state in different regions, so depending where you are, you'll call the local ombudsman's office, and they can tell you if they have jurisdiction, if they have authority over that facility. But assuming they do, they don't have to send a formal complaint or go through court. They have immediate access to the nursing home's records and documentation. And believe me, the nursing home I dealt with suddenly changed their tone and response to me pretty quickly when the ombudsperson that I contacted physically went to that facility, and we're not in a position to deny access. So I recommend that to people if you find that you're really concerned about the care that your loved one is getting. This slide kind of has their phone number, and really just go to their website. You can kind of figure out if they would be the right resource for you. But I would encourage folks to consider that. I've had good luck with that, and I think the nursing homes know that that's an organization that they want to stay on good terms with. So that's a nice accountability measure that's provided in the state, and that's a free resource to South Carolina citizens.
Yeah, and I think I would just add to that, Kirby, that I know I've seen cases as well, and had one that, you know, in particular, the ombudsman would have been a good option for the client, but by the time, you know, we had the client come to us, you know, that part was over. But, you know, that particular client was, you know, basically evicted from the facility that he was in, and had this, you know, the caregiver or family member realized that there was this ombudsman available. I think that that transition would have been a lot less traumatic than it was. It would perhaps not have ended up in a lawsuit like it did. I don't know, it might have ended up in a lawsuit anyway, but I really wish that that client had known about the ombudsman. It would have made things a little bit easier at the time of the forced discharge.
It's kind of a clunky old word, ombudsman, and the client I had kept, bless her heart, calling it the ombudsman, which was kind of cute, but just, I think folks should just think of that more as a patient advocate or a nursing home resident advocate. That's or / investigator, or that's kind of really how I think they view their job. And I've had good luck with them. Mike, have you had any experiences in your part of the state? Is that something you see?
Yeah, and you know what? They're free too. So there's no charge for that. And typically they're housed with the local area agencies on aging. I know with Waccamaw, Regional Council of Governments, for instance, I'm in the Horry County, so they'll cover Georgetown County and I think Marion County. They group them in regions. And yes, I absolutely think that should be one of your first phone calls once you've reached the end of the line as far as a family member or a loved one trying to advocate and you're not getting anywhere, it's, you know, you don't necessarily need to call a lawyer immediately. Call the Ombudsman's office first. See what they find out, see what kind of answers you're getting, and then go from there. Because the litigation process, unless there's an emergency, unless there's going to be immediate harm where you can get some sort of injunctive relief, it's a long process. And meanwhile, your loved one still needs to have those issues addressed.
Yeah, and I would just add to that that the Ombudsman can be contacted by other people as well. People who are coming in and out of the facility for one reason or another and notice something and you know, realize that maybe the Ombudsman needs to be called in, where a family member may not realize that. And so you shouldn't be, as you know, a family member, if all of a sudden the Ombudsman contacts you and you didn't even contact them, don't be afraid of it, because they're going to be looking out for the best interest of the patient. Okay. Kirby, you want to talk a little bit about transfers and discharge for behavior? I know we kind of touched on that already.
Yeah, I think Mike mentioned what's probably the most common scenario. Certain diagnoses of Alzheimer or dementia, they really do have a physical component. What you hear is combativeness, where actual staff feel they're in danger, and or just very difficult to manage that from a medical perspective. But of course, that would be much worse at home for most families, so it has to be kept in perspective. Certainly, medical facilities all know how to restrain patients, sometimes due to various different reactions to narcotics or all kinds of mental issues. So you really want to have the appropriate medical facility have that ability, and certainly don't just take the suggestion that, oh, this patient is, you know, difficult, therefore can't be here, as the conclusion. That's kind of the starting point, maybe, and certainly a reality, but not a legitimate immediate basis for a transfer or discharge without further development of what the plan is then. So next slide, Susie. We do see that there are some ways to fight that, and really some of the things that I referenced earlier, that remember that MDS and that PASRR, those forms and documents, you know, that would need to indicate from medical professionals that there is this behavior issue. If that's not in the documents, that's then no longer a predicate for that type of proposed discharge. So if you're facing that, start with those documents, look at really the alleged behavior. Sometimes it's a urinary tract infection. I know that may strike people as odd, but it's not uncommon that someone with that type of infection starts to have hallucinations and you know, acting paranoid and frustrated and physically acting out when they have a medical infection that, if properly treated, they go back to you know, normal, safe behavior. So look at medications. Many times it's the interaction of multiple medication that drives a lot of anxiety and anger and physically acting out. So if you see a recent change or you know, doctors that aren't communicating with one another, prescribing different meds that don't interact well, we've seen that as the cause of physical outbursts, that once that medical you know, medication prescription is adjusted, we've got a good behavior situation again. So that's where I would start if you're looking at an issue.
That's a really important point. I think when the behavior issues are what comes up, you gave some great examples of other things that could be corrected that may be causing the behavior. And to go back to something that we mentioned early on, which is that you have the right to have your personal doctor and you don't have to use the facilities doctor. You know, sometimes that if you make that change over to a doctor that's the one who visits that facility regularly, even though they may have the patient's medical history available to them, there might be things in there that they didn't really catch, and if they change medication, it could cause an issue that that doctor didn't expect. And, you know, I assume that you have the right to have your own doctor come in and review everything and say, well, you know, let's look at these other potential causes of this behavior.
And they can't just discharge you. There has to be a care plan in place. So what that means is they're not going to be able to say, okay, you know, husband, wife, son, daughter, come get your loved one from the facility and take them home. That's not an option for them, and they have to have a plan of care. The concern is that they find a plan of care that's halfway across the state, or worse yet, across state lines. And then that becomes a real issue that's worth, you know, fighting over, in my opinion, right? Because proximity to your loved one and being able to check in on them and make sure they're getting the care they need is important. So if you live in Horry County, you wouldn't want a discharge plan necessarily that's out in Greenville. That's a 4.5-hour car ride. It'd be very hard to get out there. This is a practical matter.
Well, we're running short on time, Susie, so we'll just talk briefly about some alternatives. You'll hear the phrase home and community-based services, HCBS waivers. So that's an option that you can discuss with discharge planners and medical professionals here in South Carolina. Maybe your loved one's condition would qualify them for one of these programs, and that can be kind of a lifesaver if you're looking for an appropriate placement. We just kind of discussed this list, so I won't go through it one by one, but yeah, if you're trying to think through, you're kind of in shock and got a limited timetable to respond to a proposed discharge, this slide could help you out. Just kind of carefully thinking through and analyzing what would be the real basis for that proposed discharge and ways that you could probably change the conversation by kind of go through these 7 questions.
Mm-hmm. Yeah, it could be something as simple as, you know, a noise factor that's causing, you know, some kind of nerve irritation. There's all kinds of things. Well, if we come to the end of our slides, there we go. This is the contact information for everyone for South Carolina Legal Services. You know, our intake office is always standing by for you to apply for our services on these type of issues and others. You can determine if you're eligible for our free services. We do have funding for seniors, obviously, and low-income folks, and so I do encourage everyone to apply. And I also, of course, need to mention that the information we've given you today is not legal advice, so you should always contact an attorney, a private attorney like Mike Large or legal services or other options that are out there to get actual legal advice about your particular issue. And you can see here that we have a lot of resources on this and other topics. We'll be linking to some of the resources that we have mentioned below. But I do want to take this opportunity to thank Mike Large and Kirby Mitchell. What a great duo. I really appreciate your level of knowledge on this subject matter, and I do encourage our viewers to reach out if they have need of an attorney for whether it's a private attorney or an outfit like us here at Legal Services. And also just a big thank you, of course, to everyone who joined us today. We really do appreciate your support. for Level Up Law and everything we do here at South Carolina Legal Services. I do want to again mention that we have Level Up Law every Tuesday at noon, and every episode is uploaded to our YouTube channel so you can view it again. You can go to that Level Up Law playlist and see all the previous episodes about all the different topics that we've done so far. Feel free to reach out if there's a topic you'd like us to address. There's always room in the comments down below to ask questions or make suggestions, so we do welcome that. Which does remind me, I should double check whether or not we have any questions from our listeners, and I don't see any right now, but I'm sure there's a lot of them, so feel free to reach out. And then, you know, I want to thank again Mike and Kirby, and also let our viewers know that next week on Level Up Law, Tuesday at noon, our presentation will be on tenant background screening. That's an important topic that we'll be bringing you information on. You know, eviction is a big problem right now, and folks are, you know, a lot of folks are having to move and find a new place. And when you apply for a lease at another apartment, home, whatever, there are background screening companies that landlords and management, property management companies use to check and see if you're going to be a good tenant. Have you had any issues with leasing in the past? And lots of times that it is made to seem like just you know, just one little thing we have to do before we can rent you an apartment. No problem. But lots of times there is a problem, and it may or may not be one that should be considered by your new landlord. Lots of times, as is often the case with credit reports, background screening reports can contain misinformation, and they are also governed by the Fair Credit Reporting Act, just like your credit report is. So we'll be talking about that next week on Tuesday at noon. I invite everybody to join us there. You can always find out about the next episodes of Level Up Law on all of our social media, Twitter, Instagram, LinkedIn. And also, when you go to look at these episodes on YouTube, be sure and like and subscribe. You'll always be able to sign up for notifications, so you'll always know when a new episode is posted. So I definitely invite everyone to check out that playlist. And if you think that this particular episode and, you know, part one as well has value to someone, to you or someone else that you know, when you go to our YouTube channel, you can share this episode with them in case they missed it. So be sure and do that as well. So that's all for today. Thanks again to Mike and Kirby for a great two-part series on transitioning in and out of nursing homes. Thanks again to our producer, Kenneth Elliott, and also all of you out there who are our loyal viewers and even new viewers. We really appreciate you tuning in. So thanks, everybody, and that concludes today's webinar.
Thanks, Susie.